Okay, hello, I'm Rudy Lara, Chair of the Beverly Hills Bar Litigation Section. Welcome to the annual SCOTUS preview with Erwin Chemerinsky and Kimberly Atkins Stohr. Before we begin, we have a few housekeeping announcements. You will receive your MCLE certificate shortly after the program. Your certificate will also be stored in BHBA Plus, our members-only community. Please take a moment to complete the survey that is included with your certificate. This program will be available in a couple of days in BHBA On Demand, BHBA's newest member benefit presented by Lawyers Mutual Insurance Company. Now, on to the program introductions. Renowned experts Dean Erwin Chemerinsky of Berkeley Law and Kimberly Atkins Stohr of the Boston Globe join us today to preview the upcoming U.S. Supreme Court term. Dean Erwin Chemerinsky became the 13th Dean of Berkeley Law on July 1st, 2017, when he joined the faculty as the Jesse H. Chopra Distinguished Professor of Law. In 2017, National Jurist magazine again named Dean Chemerinsky as the most influential person in legal education in the United States. In January 2021, he was named President-elect of the Association of American Law Schools. Now, Kimberly Atkins Stohr is a senior opinion writer and columnist for the Boston Globe Opinion. She is also the inaugural columnist for the Emancipator, a joint independent anti-racist multimedia project from Globe Opinion and the Boston University Center for Anti-Racist Research. Ms. Stohr is author of its newsletter, Unbound. She has also served as the Boston Herald's Washington bureau chief, guest host of C-SPAN's morning call-in show, Washington Journal, and a Supreme Court reporter for Massachusetts Lawyers Weekly and its sister publications. Dean Chemerinsky and Ms. Stohr, thank you so much for joining us today. I'm going to pass the mic on to you. Oh, and I should add, subject to the panelists' request, questions will be permitted if time permitting at the end, and we'll be monitoring the chat. Thank you so much. I pass the mic on to you.
Thank you so much. It's such an honor and pleasure to do this, and wonderful to get to do this with Kimberly. It is a momentous time in the United States Supreme Court. In terms of how we're going to approach this, I'll offer some overview thoughts, then Kimberly will, then she'll take a case and present it, and I'll comment. We'll do this for about 45 minutes, and then leave the remaining time for questions. I think everyone would agree that last term was one of the most historically important in all of Supreme Court history. The only analog that I can think of is probably October term 1936, when the Supreme Court overruled 40 years of decisions that had limited the powers of Congress in the states. 2 years ago, when Justice Ginsburg passed away and Justice Barrett was confirmed, I made two predictions. We would see many more 6-3 decisions. We see many fewer 5-4 decisions with a liberal justice in the majority. Simple arithmetic explains why. It's a court with 6 conservative justices appointed by Republican presidents and 3 liberal justices appointed by Democratic presidents. Last year, we saw exactly that. The Supreme Court decided 60 cases with signed opinions, debriefing and oral argument. 19, or almost a third, were 6-3. Another 9 were 5-4. And there was no major case that I could identify where the liberal justice were in the majority. But those numbers don't really tell the story. The New York Times ran a front page story right at the end of the term saying, by their statistical analysis, this was the most conservative term since 1931. It would best be known, of course, as the term where the Supreme Court overruled Roe versus Wade and Dobbs versus Jackson Health Center. The term when the Supreme Court dramatically expanded gun rights in New York State Rifle Association versus Bruin, where the court aggressively protected free exercise of religion and obliterated a wall separating church and state in cases like Carson versus Macon and Kennedy versus Bremerton schools, where the court opened the door to great limits on administrative agency power in West Virginia versus EPA. As we'll talk about, I think this term has another set of potential blockbuster cases. The primary difference from this term to last is Justice Stephen Breyer is no longer on the court. He's replaced by Justice Ketanji Brown Jackson. Justice Breyer was a very important member of the court since 1994. He was a self-described pragmatist on a court where many of the justices are much more ideologues. He was a justice who really took seriously trying to forge coalitions, often successfully, obviously sometimes not so. One area where I think there may be a real difference from Justice Breyer to Justice Jackson is with regard to criminal procedure. We often forget that Justice Breyer was often with the conservative justices in Fourth Amendment case in the last decade, in confrontation clause cases, in cases about the role of jury trial. One of the things that Justice Jackson brings to the bench is she's the first justice who was ever a public defender to serve. She's also the first Black woman to ever be on the Supreme Court. Many justices said that when Thurgood Marshall was on the court, his describing his experiences changed their minds. Some just said when Sandra O'Connor was first woman on the court, changed their minds. Well, Justice Jackson brings unique experience to the bench, and that might matter in some cases. And also it's important to remember, she's 51 years old. She's going to be on the court for decades. And even if she doesn't make a dramatic difference in the most high-profile cases this term, she might 10, 20, 30 years from now.
I co-sign everything that Dean Chemerinsky just said atop of this discussion in talking about the term ahead and where the court stands now. Just a couple things that I will add is I think one thing we will see this year that is new, besides the new justice, is the full weight of this new 6-3 majority that Dean Chemerinsky mentioned. This is going to be really the first real term where you have this court, and it is already started, seemingly taking up many cases, not just to settle law that is unsettled due to a circuit split, or that is a new unique theory of law, but a lot of times, and it seems a lot of the cases that we're talking about today, that the court has granted cert in a way that the outcome is almost certain, and that's due to the makeup of the court. I think the first time I saw a glimpse of this was with the gun case a couple years back in an order where Justice Kavanaugh essentially said, you know, I think that people are interpreting our Heller decision wrong when it comes to the Second Amendment. Fast forward 2 years and we got the Bruin decision, which really greatly expanded where Heller left off. I think with the grant of certiorari that the court is speaking in a way that it didn't necessarily speak in before, at least not as clearly. I'm also struck by this new minority on the court with the addition of Justice Jackson. You now have not just a 6-3 court, but the 3 justices in the minority are all women. 2 of them are women of color. They, among them, have a lot of diversity in professional background and geographic background and religion and other areas. So that's really the area where the diversity on this court is kind of concentrated. And on the other hand, this term in particular, we have issues, especially those that affect minority and underrepresented populations at a really large proportion. Just about all the cases we talk today have to do with race or LGBTQ rights. And considering that, I think that is one of the things I'm going to be looking out most in looking at this court. This is also the first full term after great criticism of the court's shadow docket really came to the fore. This idea that cases were essentially being decided on the merits in the preliminary phase through orders that were issued without the full briefing and arguments in cases. We've seen some justices push back on this idea. Even in one of the cases that we talk about, one of the voting rights cases, Justice Kavanaugh bristled at the idea, but we will see how the court reacts to that. Will the shadow docket be just as busy as in past terms? So with that, why don't we jump in to a discussion of the cases. I'm going to start out by talking about the affirmative action cases, Students for Fair Admissions versus Harvard and versus the University of North Carolina. The issue in this case is whether the Supreme Court should overturn the standing precedent when it comes to affirmative action, which is the 2003 case, Grutter v. Bollinger, which allowed the use of race as one of the considerations in admissions for colleges and universities. And also at issue is whether a university is bound to use a race-neutral alternative because it would change the composition of the student body. So let's go back to Grutter in 2003, which allowed universities to take race into account as one of the factors in a holistic way of admitting students. In that case, Justice O'Connor wrote, quote, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today," that of course being the interest of student body diversity. I think in the years since, it's proven that that is not the case. I know when I was in school, it was a very common occurrence for me to be the only Black student in class, for example. And as I talk to students and deans and professors in schools across the country, as I write about affirmative action, that's still something that is quite common. And universities often say, even admissions officials say they struggle to get the kind of diverse student body that they think would be best and most instructive for their classes. And that is why so many support affirmative action. This case is brought by a group called Students for Fair Admissions. The group was founded in part by Abigail Fisher, who was part of the 2016 Supreme Court case, which challenged the admissions policy at the University of Texas at Austin. She was a white student who was denied admission into the school, and she sued because one of the factors considered in admissions there was race. It was a very complex set of admissions policies that include accepting the top 10% of all students at public schools in Texas. So after that case went up and down to the Supreme Court several times, being remanded by Justice Kennedy, in the final ruling, Justice Kennedy wrote for the majority saying, race can be considered if it is very narrowly targeted as one of a complex set of factors. And it is shown that a university has tried race neutral ways to achieve the same outcomes. And in this case, it seems that the University of Texas had done just that. They used a broad range of things, some considering race and some not, in trying to get the diverse student body they had while also taking in qualified students. And in this case, it is permissible. It seemed to be a narrowing, a very, very narrow reasoning, basically saying you have to do everything you can, but if you can consider race. In dissent in that case, Justice Samuel Alito wrote, "Something strange has happened since a prior decision in this case." Alito was noting that Kennedy had initially remanded this case down and expressed some skepticism as to whether it was constitutional. Of course, now, the thing that has changed since Fisher and since Grutter is the makeup of this court, and the fact that the court has taken up this case. This term seems that they are ready to rule out the use of race at all in admissions. What do you think, Erwin?
I very much agree. I want to start where you began. This isn't a situation where the Supreme Court's taking a case because there's a conflict among the lower courts. In fact, in the North Carolina case, they didn't even wait for the Fourth Circuit to rule. It's coming from the district court. I think this suggests, as many of the cases we're talking about, this is a court that has an ideological agenda. Just a few things that I would add to your excellent presentation. First, it's important to stress that this will involve both public and private colleges and universities. The North Carolina case involves the 14th Amendment, but that doesn't apply to private universities. Harvard case involves Title VI of the 1964 Civil Rights Act. It says recipients of federal funds can't discriminate based on race. 5 justices in Bakke said that the standard for Title VI is the same as the standard for equal protection. It will certainly be ironic that at the same time the court overrules what those 5 justices said in Bakke, they'll continue that to apply Title VI and the same standards of equal protection to private universities. In a footnote in Gratz versus Bollinger in 2003, Chief Justice Rehnquist said, Title VI has the same requirements as equal protection. but they're not really the same. One's a statute and one is constitutional. Stare decisis applies differently in the statutory as opposed to the constitutional context. But that's one thing to note, that it will apply to all public and private schools. Second thing I think is important is how the court writes the opinion. I don't think that anyone, liberal or conservative, has much doubt what the outcome is going to be. Chief Justice Roberts, who may be the most moderate of the 6 conservatives, has been so outspoken against all forms of affirmative action. He so famously said in Parents Involved in Community Schools for Seattle School District No. 1 in 2007, the way to stop discrimination based on race is to stop discriminating based on race. And he's endorsed the idea of a colorblind constitution. So how does the court write this opinion? They could write it by saying that diversity shouldn't be regarded as a compelling interest. And if they do that, they will overrule Justice Powell from Bakke, Grutter, and Fisher. Or they could write it much more broadly to say the Constitution requires colorblindness. There's a difference there. Imagine that a school, let's make it a law school, wants to consider race in assigning students to sections to make sure there's not just 1 or 2 Black students or Latinx students in the section, wanting to make sure that there are students of color in each section. If colorblindness is the requirement, then that wouldn't be permissible. And so I think that it'll be important to see if they overrule those cases, how do they do it? And I think the third important thing is, what can colleges, universities then do to achieve diversity once these cases are overruled? California has had to deal with this since 1996 when Proposition 209 was passed. Michigan, Washington State have adopted initiatives. And one question is, to what extent can proxies be used to achieve diversity? Like, as you mentioned, Kimberly, the top 10% plan in the state of Texas, take the top 10% of all schools. That was clearly done with the purpose of achieving diversity, and it had some effect in achieving diversity. Is the court going to disapprove of those by saying the purpose and effect is also based on race? And so I think what the court suggests or indicates about that could be very important. I don't know if you had other thoughts about this case.
No, that's really, that's it. Other than to say, then, of course, the goal is not diversity for the sake of diversity. When you are, as I've been, the only Black person in a class, not only does it deprive other people in that class of a broader understanding of the world through their fellow students, it puts a lot of burden on those students who are in underrepresented groups to sort of represent their race or represent their ethnic background in a way that makes the classroom experience a lot more difficult. So it's important for a lot of reasons, not just for the sake of diversity.
Such an important point. If it's okay, then I'll do the next case. It's 303 Creative versus Alenis. It involves a woman in Colorado, Lori Smith, who designs websites. And she says she wants to start a business designing websites for weddings. But she doesn't want to design websites for same-sex weddings. She said that her religious beliefs would keep her from doing this, would be inconsistent with her religious beliefs to design websites for same-sex weddings. Colorado has a law that prohibits business establishments from discriminating on the basis of race, sex, religion, sexual orientation. And the question here is, should she get an exemption to the anti-discrimination law on account of her speech or on account of her religion? If this sounds familiar, it's because 4 years ago, the Supreme Court had a case also out of Colorado, Masterpiece Cake Shop versus Colorado Civil Rights Commission. That involved a baker who refused to design or bake wedding cakes for same-sex weddings. He said it was on account of his religious beliefs. The case got an enormous media attention. The Supreme Court ruled in favor of the baker, but on very narrow grounds. The Supreme Court said that there were 2 statements made in the hearings of the Colorado Civil Rights Commission that expressed hostility to religion. And because they expressed animus to religion, that then would trigger strict scrutiny, and the case was sent back to the lower courts. Now, I have to admit, I think that ruling was a stretch. I think if you actually look at those 2 statements, it's hard to see them as expressing hostility to religion, But that's how the court avoided the underlying issue. Well, now that underlying issue is back, and it's to what extent can people, on the basis of their religion, their speech, engage in discrimination that violates the law? It's notable that the Supreme Court granted cert in this case on the speech question, not the religion question, whether it violates her free speech to require her to design websites. And it's easier to see this as a speech case because it is about designing websites. Harder to see baking a cake is speech. But undoubtedly, even though the question presented is about speech, religion underlies this. And the briefing is this about her speech, or is this really about conduct? And does the government have a compelling interest in stopping discrimination? The underlying issue is so crucial. There's always a tension between liberty and equality. Any law that prohibits discrimination limits the freedom to discriminate. For over half a century, the Supreme Court has consistently said that stopping discrimination is more important than protecting freedom to discriminate. Here, I think we're going to see a majority of the justices say that it violates Lori Smith's free speech rights to enforce the Colorado anti-discrimination law against her. But if that's so, what of the employment context, where an employer says that it violates my religion to have men and women in the same workplace, and so therefore I'm going to discriminate against women? Or what about somebody who says it's my speech rights and my religion rights not to perform services to Blacks? How do you draw the line in this context? I think that's what underlies this case. But again, I don't think that there's much disagreement that the court's likely here to rule in favor of the plaintiff, Lori Smith, 303 Creative.
Yeah, Erwin, I think you're exactly right. I agree with that. It's important to remember that that Masterpiece case was decided on a very, very narrow ground. And I think that was in part because of, again, the makeup of the court at that time. That court did not have the appetite to make a broader ruling. I think taking this case this term is an indication that it does. And I want to drill down a little bit more about this conflict between laws that protect civil rights and protect against discrimination and the constitutional protection for religion. The protection for religion is important. It's in the First Amendment. It's the First Amendment of our Constitution, and religion should be robustly protected. The case of the matter is religion is robustly protected. It's protected statutorily with the through Congress. It's protected through the courts, including the Supreme Court, in its rulings. And I think a lot of these cases are brought under this false idea that religion is under attack and that it needs greater protection and more attention should be brought to it. The truth is of the matter that the protection of the practice and exercise of religion and the practice of the Second Amendment protection of the right to bear arms are probably the greatest protected rights in the Constitution. But when it comes to these freedoms, these civil rights laws, these anti-discrimination laws and rules that they bump up against, often they don't have that same level. Keep in mind, when you're dealing with something like LGBTQ folks, a lot of times that may be treated as gender discrimination, which would get intermediate scrutiny, not strict scrutiny. For race, it is strict, but in other areas, it won't be. So in the battle between religion and these other things, religion will always come out on the winning side and reducing those protections. I would look out for this in a growing number of areas. We saw religion go up against, for example, pandemic protection measures against the government, and the Supreme Court ruled on the side of religion. We've seen it go up against providing contraception coverage for employees, and religion coming out on top. More cases that are making their way up deal with things like employers objecting to paying for coverage for medications like PrEP that prevents against HIV because they express a religious objection to quote unquote immoral conduct that would lead to that. We've seen it with adoption, some adoption, private adoption agencies not wanting to adopt to same-sex couples. So this is going to expand. We're going to see more litigation in this area, and I fear that the use of religion, or in this case, speech in a religious form, will be something that people use in the courts as a sword, and that increasingly courts will be willing to go along with. Yeah. So I'm going to talk about something that sounds very strange, but is really, really important in the case of Moore versus Harper. The question in that case is, how much power does a state legislature have in setting the quote time, place, and manner rules for elections in Congress and beyond? It's something called the independent state legislature theory. It's something, if you haven't heard of it, you are not alone. I don't think I heard about it in law school or since, with the exception of a very short piece of a concurrence in the Bush v. Gore piece, in the Bush v. Gore case, which I'll get at in just a minute. Essentially, the independent state legislature theory is the idea that under the Constitution, only a state legislature has the power to regulate federal elections, and that power exists and it cannot be interfered even by state courts and the state executive. So it comes from the election clause of the Constitution, which gives the power to legislatures to regulate, quote, times, places, and manner of holding elections for senators and representatives, end quote. It was first seen in recent times, as I said, in a concurrence from Chief Justice William Rehnquist in Bush v. Gore. He argued then that the Constitution's assignment of its authority on elections to state legislatures diminishes the judge's power to alter, quote, general coherence of the legislative scheme. Basically said that judges really had no role in determining how those votes could be counted. It was up to the legislature. Even after that concurrence, this theory was mostly ignored. Well, that was until 2020, when it came up again in redistricting challenges to redistricting commissions and other election agencies in states like Arizona and Kansas and North Carolina, which is where this case stems from. When legislative maps in North Carolina were thrown out by the state Supreme Court as impermissible gerrymanders under the state constitution, and a special master was ordered to create a fair map for the 2022 congressional elections, lawmakers challenged that ruling by the state court, arguing that under the independent state legislature theory, that the court did not have the power to do anything about their map drawing. Again, the fact that the Supreme Court took up this case may not be proof that the Supreme Court is apt to agree, but we do know from past cases that at least 3 justices have expressed a willingness to consider this, Justices Gorsuch, Thomas, and Alito. We still don't know how the other judges in the majority may rule, but it's really important to underscore what this would mean. If taken to its logical and legal conclusion, this theory is adopted, what it would mean is the decisions by a state legislature when it comes to things like drawing congressional maps, setting up the manner in which elections are conducted, and even possibly in choosing electors who can go for and choose cast their votes for a presidential election, would not be able to be reviewed by the courts, and even a governor, if a law is passed, would not be able to veto it because it would be interpreted that only the people in the state houses, the elected legislatures of that state, would have a say in how those elections are administered. Given what happened in 2020 and since in the efforts to deny the results of elections, this can have really potential disastrous results. So for me, this is the most important case on the court's docket this term.
I can't disagree with that characterization. Imagine the following. Imagine the 2024 election is as close as the 2020 election. And imagine a few states have Republican-controlled state legislatures, Wisconsin, Georgia, Arizona, And though the Democratic candidate wins the popular vote in 2020, the legislatures choose to give the electors to the Republican candidate, which switches the Electoral College and the Republican wins. I truly believe if that happens, our country will come apart. I mean, I think those are the stakes that we're talking about. And that's why the independent state legislature theory matters. The only thing I'd add to your great description is a little bit of context. In 2019, in Rucho versus Common Cause, the Supreme Court said that challenges to partisan gerrymandering can't be heard in federal court, that they're non-justiciable political questions. That case also involved North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, Romney in 2012, Trump in 2016 and 20, but always by close margins. In 2020, Trump beat Biden by 1.65%. When Republicans took control of the legislature, they then sought out to draw congressional districts to give Republicans control of 10 of 13 seats in Congress from North Carolina. And the person who was in charge said if they could find a way to draw the map to give Republicans 11 of 13 seats, they would have done that. They ran 3,000 possible maps and chose the one most likely to give Republicans control of 10 of 13 seats. So in 2018, Democrats and Republicans statewide got almost identical number of votes for congressional seats. It was 50-50, but Republicans won 10 of 13 seats. After the 2020 census, Republicans went to do the exact same thing. And the North Carolina Supreme Court said, no, this violates the North Carolina Constitution. And this is what's now before the Supreme Court, as Kimberly said, with the challenger saying, the North Carolina court doesn't get a voice in this. I mean, that's troubling because even when powers are given to a legislature in the Constitution, the courts always get to still enforce the Constitution. Congress has the power under Article 1 take action, but the Supreme Court, pursuant to Article 3, can decide, is it constitutional? This would completely disempower state courts, or as you say, governors, from being involved at all. Now, this provision is about Article 1, Section 4, which involves Congress with regard to setting the terms for congressional elections. But if they adopt the independent state legislature theory, then I don't see why it wouldn't also apply to Article 2, Section 1, that gives the legislatures the ability to determine the electors from a state. So when you say this is the most important case on the term, if the court adopts the independent state legislature theory, you're absolutely right. It would say state legislatures get to do whatever they want. Courts are disempowered. And in this case, I think there's a strong argument that the North Carolina legislature, or more specifically the North Carolina Constitution, have delegated this power to the North Carolina courts. And if the court says even that's not permissible, that the legislature always gets the final say, the implications are potentially enormous and dramatic. Unless you have other comments, should I do the next case?
Yes, I think so.
Which is also a voting case. It's a case called Merrill versus Milligan. It comes out of Alabama. And as we've already alluded to, after the census, there's always redistricting. In Alabama, like every state, engaged in redistricting. Alabama has 7 seats in Congress. And the way the districting is done, there would only be a likelihood of a Black majority in one of those 7 seats. And that's about 1 out of 7, about 14%. Blacks are about 27% of the population in Alabama. A 3-judge federal district court declared this to violate the Voting Rights Act. It's notable that the 3 judges, 2 were Trump appointees and 1 was a Clinton appointee. And they said that this likely violates the Voting Rights Act and ordered that new maps be drawn. And they applied a test that the Supreme Court articulated decades ago in Thornburg versus Jingles for determining when districting violates the Voting Rights Act. Alabama went to the Supreme Court for an emergency order to stop the new districts from being used that were drawn in response to the court decision, and instead to require that the legislature's districts be drawn. And to my surprise, the court, in a 5-4 decision, stayed the lower court and said that instead what should be used for the primary and for the November election were the districts that have been found to be discriminatory. it was the five most conservative justices: Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. Roberts joins with Breyer, Sotomayor, and Kagan in dissent. There's no opinion for the court. This is on what Kimberly referred to as the shadow docket, a request for an emergency order. But Justice Kavanaugh wrote his own opinion as part of the majority, saying, this is because of a Supreme Court ruling in 2007 in Purcell versus Gonzalez. In Purcell, the court said that federal courts should be reluctant to get involved in elections soon before the election. This has even come to be called the Purcell principle. And usually it's been in a situation where a day or days before the election, the federal court might get involved. You might remember in April of 2020, right before the Wisconsin primary, a federal district court extended the time for absentee ballots. Because of COVID, there was such an increase in absentee ballots, they couldn't all be processed. And the Supreme Court in Republican National Committee versus Democratic National Committee said that this is too soon before the election for a federal court to get involved, the Purcell principle. But that was days. In Merrill versus Milligan, it was months before the Alabama primary and many months before the November general election. But still the court said, based on Purcell, or at least Justice Kavanaugh said, that's how they were doing it, the federal court shouldn't get involved. This by itself has huge implications for the future. It always takes some time after a census to draw new districts. It would seem to be very difficult to challenge those districts in the first election that we held under them. I think that here there's a strong argument this violates the Voting Rights Act. But imagine even more egregious race discrimination in districting. It would seem what the court's saying is the federal court can't get involved soon before the election, even when soon as months before the election. The Supreme Court stayed the three-judge court ruling and then granted review in the case. They're going to hear the case on October 4th. In July of 2021, in Brnovich versus Democratic National Committee, the Supreme Court made it much more difficult to bring challenges to state and local election practices as violating the Voting Rights Act. Now the court's considering how does that apply to districting? And I think many worry that what Brnovich did for various requirements for voting, making them harder to challenge in the Voting Rights Act, this case may make it much harder to challenge districting. So what the court's already done has significance to the future, but many worry that the Supreme Court is going to further weaken the Voting Rights Act when it comes to protection against race discrimination.
Yeah, I could not agree with everything Erwin said more. To me, I see this case as sort of the third leg in a three-legged stool. First, in Shelby County in 2013, you had the court really eviscerating the Section 5 power, which gave the DOJ the ability to proactively and preemptively deal with districts or voting rules imposed by states that could be discriminatory with the preclearance process. That is gone. With Brnovich, the court turned to Section 2, which was all that was left, which was already more difficult and harder when it came to remedying voting violations because it was after the fact. It allowed people to bring challenges after voting rules were put into place or after district maps are drawn, but it allowed them to challenge them as discriminatory. Brnovich made it harder when it came to certain election rules, like those that erase people from voting rolls or made it harder to count ballots that were cast in voting districts and voting precincts that may have changed since the last time someone voted. Usually they can vote by a provisional ballot, it would be counted later. It made it harder for things like that. Now you have the third leg of that stool, which is the use of Section 2 to challenge district maps, and that also is in peril. It's really hard to see how much of the Voting Rights Act is left after that. So should we talk about another case?
Sure. Do you want to talk about Burkine?
Yes, I'm going to quickly go through Brackeen, which is one I think is one of the sleeper cases that hasn't gotten a lot of attention, but is really important. It involves something called the Indian Child Welfare Act of 1978. That was enacted at a time when an alarmingly high number of Native American children were ending up in the foster or adoption systems. And at the time, the children who were fostered or adopted were, in the vast majority period of the time, more than 90% of the time, adopted to or fostered by non-Native families. So this law was passed in order to give a priority placement system for these children, which means that if this child is to be adopted, it would go, preference first would go to an immediate family member, a grandparent, an aunt, a cousin. If that was not available, it would be someone else within that tribe or nation. If that was not available, then it would be another Native family. And if none of those were available, then non-Native people could be eligible to adopt these children. So this case was brought by a couple who sought to adopt a child who they were fostering, but was told that they did not meet the priority. They would have to wait to see if other adoptive parents were available. And they sued, saying that it was an impermissible race discrimination under the Equal Protection Clause of the Constitution. It's important to note that ultimately they were able to adopt the child, but this case still made its way up to the US Supreme Court. Because they were able to adopt the child, and it's unclear exactly who qualifies to bring this kind of challenge, it's possible that this could be dismissed on standing grounds. But if not, this gives the court an idea, an opportunity to determine if this law is actually a law that discriminates on the basis of race. Now, those who support the law, the state and the federal government, are saying, no, this is a law that is based on status as a member of a Native American tribe or nation, which is more of a political designation. And the people within that group have the right to establish what the criteria are for membership into that group. And those criteria go far beyond just race. It is not just a racial determination. And again, the implications of this are potentially broad. If this is deemed to be race-based discrimination, then any number of federal regulations that were put in place due to the federal government's obligation to protect Indian tribes and nations and their communities can be in constitutional peril if they are seen as a race-based classification. And it's one of, as I said, many cases, this term, that involve race in a really fundamental way, and the possibility that the desire to, as Erwin said, create a sort of colorblind constitution can actually have the negative implication to take away tools by our federal government that are meant to better protect some of its citizens. So this is something that may not get a lot of media attention, but it is really, really important.
Let me just take one moment to describe very briefly another case, and then we'll be able to take the 15 minutes questions. I agree totally with your description of Brackeen and why it's so important. I just wanted to mention a non-constitutional case, the Andy Warhol Foundation versus Goldsmith. And there's a copyright issue of what does it mean for work to be transformative? And specifically, it looks at this in the context of the visual arts. Here, Lynn Goldsmith did a very famous picture of Prince. Andy Warhol did a number of different prints with regard to this. And the question is, did Warhol transform the Goldsmith pictures, or was this a copyright infringement? And this matters because under copyright law, in determining fair use, one of the most important considerations is whether or not the work is transformative. The Federal District Court in New York, Judge Kodal, found that this was transformative and went through many different reasons why it should be transformative and therefore should be deemed to be fair use. The Second Circuit, in an opinion by Judge Lynch, reversed and disagreed both with inclusion and also very much disagreed with Judge Kodal's reasoning about how do you determine what's transformative for purpose of fair use. There's certainly been other cases about whether something is transformative. In Google versus Oracle a couple of years ago, the Supreme Court found that something was transformative and therefore found fair use. But I think that this is interesting because it just comes in a different context, the visual arts context.
I find it interesting too, not just because I'm a big fan of both Andy Warhol and Prince, but I will be looking out for that case as well. So I want to take some questions that we've received in our Q&A. The first one, and I'd be interested in getting Erwin's observations about this phenomenon. The question says, every justice on the court is a graduate of an Ivy League law school. Do you see any future openings for a non-Ivy justice? I know a Carolina woman was supposedly a finalist. Just one fact check, 8 of the 9 justices graduated from Ivy League law schools. Justice Barrett graduated from Notre Dame Law. But Erwin, just on this idea that it is a very Ivy heavy Supreme Court, that's one way that it is not very diverse at all. What are the implications of that? And do you think that it's important and possible to sort of break that ivory tower?
I think they need more Berkeley Law graduates on the court.
I knew you'd say that.
Earl Warren was the last Berkeley Law graduate on the court, and he did pretty well as a justice, a chief justice. I think this is a symptom of a larger problem. I mean, I worry that there are very few justices who have trial level experience. Thankfully, one thing that Justice Jackson brings to the court is she was for a long time a federal district court judge. She was a public defender. Justice Sotomayor had been a prosecutor, and she too had been a federal district court judge. But I think that the court doesn't give nearly enough guidance to trial judges who have to deal with issues day to day. And I think having more trial judges on the court would be important in that regard. I think that geographically, the court is very skewed. I think right now that Justice Gorsuch is the only justice from west of the Mississippi, now that Justice Breyer has stepped down. And so I think that's important. 8 of the 9 justices, all but Justice Kagan, were federal court of appeals judges. And, you know, I think the court that decided Brown, none of the 9 of them had been court of appeals judges. So yes, I'd like to see the court being more diverse in all sorts of ways. And I think where they went to law school is just a small part of that. What do you think?
I agree with that. I think that diversity in general, geographic diversity, as you mentioned, is an important one as well, is really important. I think perhaps one way that you get at that other kind of diversity is diversifying where you look in terms of law school graduates, because the people who have worked in state courts or state trial courts or other places are often people who are graduates of non-Ivy schools, and that in itself begets that kind of diversity. But I agree with what you said. Another question is, speaking of the shadow docket, any predictions with respect to the Trump special master decision, which undoubtedly will come before the SCOTUS in short order? I think that's probably one of several Trump-related issues and cases that will come before the court on its emergency docket. Erwin, any predictions?
I don't know about predictions other than to say that I think what the federal district court Judge Cannon did here is really extraordinary. I'm teaching criminal procedure this semester, so I spent some time with my students. Almost always in federal court, warrant matters are handled by the magistrate judge. Here, it went to the district judge. I'm not sure how the district judge had legal authority to do what she did. Now, there are instances in which special masters are appointed to review documents. It's usually in the attorney-client privilege context, where if a lawyer's office is searched, a special master will be appointed to review the materials to make sure that no attorney-client privilege material is turned over. There is mention of attorney-client privilege here, but even more what it's about is executive privilege material. President Biden is not invoking executive privilege. Does an ex-president have the authority to invoke executive privilege? Even more, in her initial ruling and in a refusal of a stay last Thursday, Judge Cannon stressed that this is a former president of the United States. She said that was quite important in her ruling not to stay her earlier decision. And she said in the earlier decision, it might be embarrassing for materials to come out that have been gained through a search. Well, that's true of every police search. It might be embarrassing. So I think as a matter of both procedure and substance, the judge's ruling is quite flawed. There's an emergency appeal to the 11th Circuit. And then whatever the 11th Circuit does, I assume it'll go to the Supreme Court and as part of the shadow docket. You asked me for a prediction. I think here that the trial judge is really exceeding her authority, and I don't think there's grounds here for a special master. On the other hand, it's President Trump, and so it's all very political.
Wow, that's really interesting on the authority issue. I hadn't given that a lot of thought. I have given a lot of thought to the issue of executive privilege, which I just find absolutely mind-blowing, because not only, as Erwin said, does it not seem at all clear that a former president has even the ability to invoke executive authority. In this case, it would be invoked against the Justice Department, which is a part of the executive branch. I don't know how you can claim executive authority against the same branch. So I just don't see what legal leg any of this stands on. And I don't know how a court would uphold any finding of that. The next question, how was the Dobbs opinion draft released? Well, if I knew that, you would know that because I'm a journalist and I would have reported it. But Erwin, do you have any clue in how that leaked?
Obviously, I don't. And I wonder if we'll ever know.
Yeah.
Was
I
it a
agree
law
with you.
clerk? Was it a liberal clerk or a conservative clerk? Was it a justice? Was it a liberal justice or conservative justice? Was it an employee in the court? Was it somebody who more agreed with Dobbs or more disagreed with Dobbs? What I found most surprising about all of it, I mean, obviously the leak was shocking in itself, but that the final opinion didn't change very much from the draft opinion.
Yeah.
That I would have thought that that Justice Alito's draft was going to be toned down before it was released. You know, to say that something your colleagues did was egregiously wrong and exceedingly poorly reasoned, I wouldn't say that about a former professor that I disagreed with. And remember, all 5 justices in Casey were appointed by Republican presidents. 3 of the 7 in row were appointed by Republican presidents. So this is such a sharp criticism of even colleagues in the same political party. But how did it get released? Who did it? I know no more than Kimberly does.
Yeah, that's a really good and important point. I thought the same. I thought that perhaps this was an early draft that was, written with fervor by Alito, and after being circulated to the other justices, that the final version would be a lot different, and it wasn't. Again, everything Erwin said is true. We don't know who released it or why. In this case, if it was released by someone on the conservative side in order to hold that majority together, perhaps it worked, or perhaps it was unnecessary. If it was written on someone on the other side seeking to try to break up that majority, it didn't work. So in the end, who really knows? The next question is, can you please share your thoughts about the lawsuit brought by Jewish organizations arguing that the Dobbs decision and its inevitable ripple effects infringe on the practice of Judaism? Do they have a realistic chance of reaching the Supreme Court? And if so, how might the court react? So essentially, the theory of this case is that because people of some religions, including Judaism, believe that life begins at birth, then the banning of abortion in the states that do it amount to a breach of their religious freedom, in that they would be unable to do it. Erwin, what do you think of that legal theory?
I think the legal theory will work as an as-applied challenge for a woman who says, my religion requires that I have an abortion where my health would be in danger. I live in a state that does not allow abortions where my health is in danger. Because the fact that somebody's religion allows something that the law prohibits doesn't create a conflict in terms of free exercise. Where there's the conflict is where the religion requires something that the law prohibits. And I think it's the situation that I described, where imagine in Florida, the exception for abortion is only for life of the woman. There's no exception for the health. And imagine that her religion says, if your health is in danger, your health takes priority over the fetus, you're required to get an abortion. I think in that situation, she has a very strong challenge, but it's an as applied challenge to her. It wouldn't be a basis for striking down the whole law. It wouldn't be a basis for saying the law is facially invalid.
That's very interesting. Another question I think is interesting as well. Is stare decisis effectively dead? I'll start because I really want to hear Erwin's thought. I think that it is endangered in at least in terms of the way I thought of stare decisis in law school, and since that it was a very high bar to overturn past existing precedent. Something would have had to fundamentally change in the facts or in the state of the law in order to go back and change, or it has to be something that is so fundamentally unjust that it would necessitate the overturning of a past precedent. But I don't see that happening here. I certainly don't think that in the Dobbs decision that it reached that threshold. I also think there is a willingness to do what I call soft, it's sort of a soft disregard for stare decisis within decisions that even don't necessarily overturn a past precedent, but that change the standards of determining the constitutionality of something, or the standards by which a statute is interpreted in a way that fundamentally changes how these the statutory or congressional interpretation happens in the future. We saw it last term when the Lemon test was thrown out, for example. I think that is also something we're going to see increasingly from this court. What do you think, Erwin?
There's long articles and books written about stare decisis, and they always come to the same conclusion. Precedent should be followed except when it should be overruled. And of course, that's the only possible answer. Almost everyone believes precedent matters because it provides stability and predictability in the law. Now, Clarence Thomas says explicitly he believes precedent should be given no weight. In fact, he gave a speech in Atlanta in June where he said, stare decisis is just an excuse for laziness. He says we should follow the original meaning of the Constitution and pay no attention to precedent. But relatively few people would go that far. On the other hand, we all believe there are instances where precedent should be overruled. It was imperative that Brown versus Board of Education overrule Plessy versus Ferguson. I think that this is a court that gives relatively little weight to precedent when it wants to overrule decisions. Of course, we've talked about Dobbs overruling Roe. You mentioned Kennedy versus Bremerton School saying that the Lemon test for the Establishment Clause has been overruled. But there are other cases in this court. Think of Janus versus American Federation in the labor law context that overruled the Boud versus Detroit Board of Education, or Nick versus Township of Scott, which in the takings context overruled Williams County versus Hamilton Bank, or a case that I argued and lost in the Supreme Court, Franchise Tax Board versus Hyatt just a few years ago, overruling a 40-year-old precedent that a state could be sued in another state's court. Justice Breyer wrote a dissent there saying there has to be a better reason for overruling a precedent other than we have a majority on the court today that disagrees with it. So I wonder what else is about to be overruled. That, of course, was prescient. In Dobbs, the three dissenting justices said, could be clear about what this is. It's just that the justices who are now on the court disagree with the earlier decision. It's no more than that. Now, in fairness, I think had Hillary Clinton won in 2016, and had she replaced Justices Scalia, Kennedy, and Ginsburg, Citizens United or District of Columbia versus Heller might be considered for overruling. But I don't think this is a court where precedent's going to matter much. And I think we'll see it in the cases you began with, the Students for Fair Admission versus Harvard and Students for Admission versus University of North Carolina. I expect there the court's going to overrule precedents that have existed since Bakke in 78 or Grutter in 2003.
Yeah. Well, an hour goes by really fast when we're talking about these important cases. I want to thank everyone for joining us and throw it back to Rudy Lehrer for some final thoughts.
On behalf of the bar, we want to thank you. It was an incredible program and you covered so much within just 1 hour, and were able to answer a lot of the questions. It was an incredibly insightful program. We are very, very grateful. Thank you everyone for attending. And again, I thank the panelists. They're all stars and we're very grateful. Thank you.